Hello, million dollar product community. Excited to bring you today's featured content, which is our chance to learn from a true professional when it comes to patents and ways you can protect your idea. We're here sitting down with Stephen Beuerle, who's a partner at Procopia Law Firm in San Diego, and he's going to give us tips and suggestions on ways to protect your idea. As mentioned prior, anytime you're developing a product and need to protect it, you'll start off by doing a patent search as your first step. Then you'll look to move to file provisional patents, and then following that, your non-provisional patent. As always, I suggest consulting a patent attorney to help you if you can afford it, because they're experts and they know how to write and interpret the small details that will help you get your patent granted. Our goal is to help guide you through this process and avoid any potholes that may trip you up along the way. We also want to give you tips on how to do your patent search or file your provisional patent on a budget, and we are in for a treat today. Stephen has over 20 years of experience assisting small businesses and entrepreneurs and brings a unique skill set, being the fact that he's experienced bringing his own products to market and is the inventor on 20 patents. He has work based around and focusing on mechanical, electrical, computer, and biotech areas, including toys, medical devices, implants, consumer electronics, exercise equipment, musical instruments, children products, and more. He also has experience with trademark prosecution, copyright prosecution, intellectual property due diligence, and licensing. Outside of that, he's worked with companies all over the world, including Japan, China, and Hong Kong, along with domestic companies, to help protect their intellectual property here in the United States. He also, outside of being very involved in the community, has been recognized by Martindale-Hubbell with an AV preeminent rating, along with San Diego Magazine over the last few years, rating him as one of the top lawyers here in town, and listed by American Registry as one of the best, America's most honored professionals. Stephen, so excited to have you here with us. Thanks for giving us some of your time and helping our community learn. How are you today?
Good. Thanks, man. It's a pleasure to be here.
Great. So just before we jump right into it, I'm excited. Stephen and I, for all of you that are listening, have gotten to know each other a bit over the last year or so as he helped me with some of my patent work. I've always been fortunate enough to consider Stephen a friend, and certainly have enjoyed learning from him. So I'm hoping today gives you a lot of content. But with that said, it's going to be light, it's going to be informative, and I want to jump right into it now. So Stephen, currently you're a partner here at Procopia. How long have you been practicing law?
Yeah, so I've been practicing law over 20 years, a little over 20 years. I've been a patent attorney.
Okay. And was there anything, what about being a patent attorney drew you to that? Obviously, I know you have a background as a mechanical engineer, and you're an inventor yourself. Did that have something to do with your desire to be a patent attorney?
Yeah, I mean, the way it all started was I was in engineering school, and I was interested in other options, graduate options after undergraduate in engineering. And so I explored, becoming a medical doctor, going on to graduate, maybe getting a PhD in engineering. I also looked at getting an MBA, and then I also looked at becoming a lawyer. My grandfather was a lawyer, and it seemed like an interesting profession. And while I was in engineering school and also working at Ford and General Motors, I got to learn more about this role as a patent attorney, where those are people that have a technical background, engineering or other hard science, and then also go on to law school, and then they work with inventors and technology companies on protecting their innovation. And so I heard about that while I was in engineering school. Got to meet with in-house attorneys at both General Motors and Ford, and sounded like a really neat profession. So I went for it and went to law school, and continued on, and here I am today.
And Stephen's worked with a lot of entrepreneurs. I have been fortunate enough to attend some of the networking events he'll host, and it's always exciting to see and meet the entrepreneurs. I enjoy it. I know part of what I look forward to is just that networking, and I've certainly been able to make some great relationships through your network and some of the things that you've hosted. Want to jump into some of the context with young entrepreneurs, especially newbies that are starting. They've come up with this great idea. They start to go online to Google and Amazon, and they're typing in, okay, maybe my product's an idea for a water bottle that infuses fruit. I've looked online, I've searched a bunch of keywords, and I want to start to look at the USPTO site, at least for myself, do a preliminary search. What are some things, or what is some advice that you would give somebody in that position to go through and try and find as much content on that site?
Yeah, well, I think going to the USPTO.gov site, you can do patent searching there. There's all different types of searching you can do there. You can do quick searching, and there's structured searching, and it's just a matter of just playing around. And they give some examples on searching, how to search, and so it's a good place to start to see if anything is out there that that's close to one's invention or dead on, with respect to one's invention. Of course, the google.com/patents is also a great site for doing free word searching, and you can find a lot there as well. And I recommend both those sites for doing some cursory searching. And then, following up that with, I recommend professional patent search. And probably half of our clients will do a professional patent search, and probably half will not. The out-of-pocket expenses for doing the professional patent search, generally on the range of $550 to $650 are what the professional patent searchers charge. And those searchers, a lot of them are former patent examiners. So they've been doing this day in and day out for 10, 20, 30 years. And they really know patent searching, and they have much better tools to do that. They're also more familiar with the technical art groups at the patent office and where someone's invention would fall, which is another area of searching that they can get into. It's not available with respect to a USPTO search or a Google search.
Good. Yeah, and I know from my experience, I've learned that even a single word sometimes can make or break a patent being granted. I know myself, I'm my background being a nurse, I don't have that kind of technical expertise, even though I try at times to make it look like I do. But it's important. And you talked about the technical art. Could you maybe explain what you mean? What is the art that goes with a patent, and why is that relevant when you're searching patents?
Yeah, so at the patent office, when someone files a patent application, and I'm talking about a non-provisional patent application, because that's a regular application that gets searched and examined and hopefully issues as a U.S. patent. When that application is filed, one of the initial things that is done is the application is examined, is reviewed, and most of this now is done automatically. It's a computer algorithm that goes through the subject matter of patent application, and then does a preliminary assignment of the what technology area this falls into. And then the patent examiners are of all different technical backgrounds, and in one technical area you might have 2, 3, 5, 10, 100 different patent examiners that are assigned the cases that come into that particular technical art group. And so that's when I refer to searching specific technical art groups, that's what I'm referring to, are these art groups of the patent office where the patent examiners are assigned and they have knowledge. And that's something that patent searcher, especially a former examiner patent searcher, would have a lot more familiarity with and be able to search into those particular art groups.
And when you talk about the art groups, and if you're looking at, say, a product that is used in the kitchen and it has a unique design, and an inventor sees that and goes, hey, I could use that on a garden hose and it would actually make the garden hose do these 3 other features. Wouldn't that be great? Does that patent for the kitchen product, even say it's a design or a utilitarian function, would that be applicable to preventing that individual developing his idea for the garden hose because they're different fields? Or does that artwork and that patent itself, would it prevent them from pursuing that other idea?
Yeah, so when you say prevent, there's 2 things I think we need to talk about. One is infringement, and that often is the bigger concern, is an inventor infringing someone else's patent? And so in that case, one would need to look at that particular patent that's on that product and the claims of that patent, and determine whether what's being proposed falls within the scope of that. Now, if someone had claims to just the product itself, the mechanical features of the product, it doesn't really talk about the use of it, then someone using it for a completely different use could still infringe the features of that patent that talk about the features and don't really talk about the use. But if the claim refers to a method, then and the method is tied to a specific area, then if someone is using it in a different area, then they very well might avoid that patent. So it really depends on the claims of the patent and how they read.
And are those things that if an individual is doing that patent search on the USPTO site, are they able to, is there a certain point they should look for to differentiate whether it's only being used a certain way or if it covers other areas of use?
Yeah, the way that would be determined is looking at the claims of the particular patent. So that was the one area I wanted to mention. The second area is from a patentability standpoint. And so these references, patents that one comes across while doing patent searches, the other question is, what's the effect of those references on patent novelty and patent obviousness, which are the two main requirements for getting a patent at the patent office. And so that's a little bit of a different analysis. And so if there's a reference that discloses the same product, but you're using it for a different purpose, what's going to happen at the patent office is they're going to consider whether using that, whether it would make sense for one ordinary skill in your art, whatever area you're going to be in, to take this other reference and combine it with another reference to arrive at your invention. And so that's a subjective standard, and that's the type of thing that as a patent attorney we argue with the patent office over all the time on whether something like that is obvious.
Okay, thanks for clarifying that. What are some commonly missed parts of a patent search that most newbies would miss if they go online? What are maybe some tips or suggestions you could offer to make sure people focus on doing a few key points to help avoid any pitfalls?
Yeah, I think the key is when doing the patent searching is to search different words. You mentioned this earlier. Use different words in your patent searching, because the way that the patent application is drafted by someone like me or the inventor, him or herself, people use different words to describe the same thing, and so you want to use different terms in doing your searching, and then that'll bring up more patents. There's different areas you can search. You can search the title. You can search the assignee or owner of the patent. So you might be aware of a company or companies in a particular area, and just knowing the company name, you can add that into your patent search, and you can really narrow down your search with that. Maybe adding a keyword or two in the title, or just some keywords as well. So there's different things that you can focus on in a patent search to help you get more accurate results.
I think that's a good point you bring up, because when you go to the USPTO site, it's easy to feel overwhelmed. There's patents that have been being issued for 2 decades there that are just piling up, and I think being able to sort via company name or title of what you're creating is a great first step to try and isolate the results that you would find online. I know that there's a lot of times, and you'll hear people say that you're not going to create anything new in this world. Everything you want to create has essentially been created in some capacity. Now, you might have built a better mousetrap, and there might be something specific that can help you, but most times when you do a patent search, you're going to find something similar online, and your variation may be slightly different, and that's fine. But when you're doing your patent search, then it allows you to really find the few that USPTO site will bring up via that search, and allow you then to really comb through those with some attention to detail to find out if it specifically lays out and covers what points you think your product accomplishes. So what would be then some deciding factors that would automatically stop somebody from pursuing their idea when they start to do that patent search? What would be some things you typically would find that would make you go, hey, it's not worth pursuing, this isn't going to work?
It really depends on the person. I mean, there might be something dead on at the patent office, that's exactly the same as what an inventor is planning on doing, and based on that, patent protection might not be available based on that prior art, or one might be infringing someone else's patents. So, for example, in the first instance, a reference that might be over 20 years old might prevent, that might be dead on, might be exactly the same as what an inventor plans to pursue, and that might prevent someone from getting patent protection. But because that patent is over 20 years old, it expired probably, and so that patent's not going to prevent someone from making, using, and selling the invention. And so someone might decide, you know what, I'm going to take the chance of not having patent protection and be the first to market and go ahead with this product and just try to compete based on quality and or price or marketing or other factors that are important for having a successful product. So that's a position someone could take. I mean, I generally recommend that they have patent protection if they're going to come out with a product, because especially if it's an individual without a huge financial backing or a company lined up to help distribute or sell the product, you might be in competition with some other big companies that might be able to come up with a product a lot cheaper and distribute it on a much wider scale than one would be able to. All your time and effort and money might be wasted to a large extent if you did pursue that product only for someone else to copy it, because one did not have intellectual property and particularly patent protection. And then the other issue is, if there's a patent that's still active, it's issued in the last 20 years, and one can search to see if the maintenance fees have to be paid, because maintenance fees have to be paid on a patent at 3 different times during the 20-year life. And if that patent is active and one infringes it, well, then one has to seriously be concerned about spending the investment and time, effort, and money and coming out with that product, only to get a cease and desist letter or face a lawsuit by the owner of that patent. So that certainly someone would want to be very weary if they see a patent that's very close and then realize that the claims appear to cover what they're doing.
So I want to just go back. You said a couple things that I think were worth clarifying for our group. If someone files a patent, it gets granted today. How long is the patent good for?
Yeah, as long as the maintenance fees have been paid, and the maintenance fees are due at 3.5 years, 7.5 years, and 11.5 years from the date of issuance, the patent will expire 20 years from the priority date of that patent application filing, which is typically the filing date of the application. So that's the typical term of a patent. Now, that's for utility patents. Design patents have a 14-year life, and it's 14 years from the date of issuance, and there's no maintenance fees on a design patent.
Okay, so somebody, we'll say 21 years ago, came up with a great idea, filed a patent, got it granted. Whether or not the product was successful or not, it's now 21 years later, so the patent is no longer active. Can anybody reapply for that same patent to get their own 20-year window to sell it themselves, or is it now just an open idea to the market and it's every man for themselves?
Yeah, so one cannot apply for the same invention that's already been patented and is in the prior art. And once that patent expires, the technology belongs to the public basically, and so anybody can use that. And there's an exchange basically that occurs with a patent, and the United States government, in exchange for essentially a monopoly on the invention, 20-year monopoly on the invention, one has to after that 20 years, basically offer up their technology to the public. And so that's what that exchange basically, in effect, happens at the the termination point or expiration date of that patent.
And when you go through, and I know when I started to file my patent, especially with my recent invention, Step to Bed, I thought, hey, this could be the game changer I've been looking for a long time, and I want to get the patent done right. I used a firm to file my provisional patent. We know that the actual filing fee is $65 if an individual were to do it themselves. The firm that I used charged me $1,000 to do the work themselves, and what I found was they sent me a big packet with a lot of questions and they said fill it all out. They went through and reworded it to sound good, and then they submitted it. So I think that there's a lot of value in the way that I did it, because I really felt like the product was worth it, and I knew that I was going to pursue it long term. Is there a tipping point that you would recommend for entrepreneurs? Does it come down to strictly their own financial capacity to hire an attorney, or in another instance, well, it's maybe a certain category of a product, and it may not be as as rewarding financially if they're able to have success with it. Is there a certain point that you would tell somebody to either file a provisional patent themselves or to use an attorney, or is it always best to consult a professional?
Well, I think it really depends on someone's budget. The financial budget they have for their innovation and technology, and how they want to divide up that budget on the various items. I mean, there's if someone has a product, someone has to consider developing the product, manufacturing the product, a website or other marketing for the product, and then along with other factors, protecting the product through intellectual property and particularly patents in this instance. And so I think someone has to look at their financial, what they want to set aside for this, and based on that, they can determine where they want to spend the money. If someone only has a few $100s they can set aside for filing the patent application, that's probably going to prevent a patent attorney being involved. Probably for a patent attorney being involved, you're probably looking at, like what you said about $1,000, for a patent attorney to be involved. And less than that, and particularly if you're talking like a few $100s, if that's all you really have for a budget, then I would recommend, filing the provisional patent application on one's own. And the key there is the mistake that I see is that you want to have enough information in the provisional patent application so that one with ordinary skill in the art can make and use the invention without undue experimentation. That's the standard. And so what I see is just often not enough information or the wrong information in a provisional patent application prepared by an inventor. And so that's something that most patent attorneys could help on, making sure that the right information and enough information is in that patent application filing, provisional patent application filing, to meet that standard.
Yeah, you bring up a great point there about developing and writing your provisional patents so that way somebody with non-technical knowledge can understand and execute what it's supposed to do without meddling with it. Throughout the Million Dollar Product Community Group, a lot of the skills that our members will be learning will be communication skills and how to present information in the most clear, concise ways, and certainly something that everybody is continuing to improve on because it's a difficult skill set to have. But I appreciate you going through and just explaining that's a key point that I think is oftentimes missed if you're going to be a young newbie that's going through and has this great idea of how do you write the patent for that provisional patent. Can you explain what the timeline is for a provisional patent from when you file it to what happens next?
Yeah, so on a provisional patent application, you file that, and let's say you file it, January 1st of a given year. You have 12 months from that date to get your non-provisional patent application, as well as any foreign filing on file within 1 year. So it would be January 1st the following year would be the deadline for both of those. And the non-provisional patent application is a regular patent application. It's going to have there's a number of sections in a patent application that have to be in there to be examined by the patent office. And most importantly is the claims section. That's the legal section. And that's a section that inventors really need the help of a patent attorney the most on, because it's kind of an archaic style of writing that the patent attorneys know, and it's hard for someone who hasn't been involved in that for years to really understand how to write in that manner. And then as a result, if someone doesn't enlist the help of a patent attorney, there can be problems with the prosecution or processing of the patent application with the examiner if the inventor is not familiar with that type of claim style. But that's the non-provisional application due within 12 months. And then foreign filing, most of our clients, they're interested in foreign patent protection. They file what's called a PCT, which stands for Patent Cooperation Treaty International Application. And that is also due at that 12-month point. And that's assuming that one has not disclosed the invention or put it in the hands of the public before that year prior, that provisional patent application filing date. In the United States, there's a 1-year rule where within 1 year of someone putting their invention in the hands of the public, they have 1 year to get their provisional patent application or non-provisional patent application on file. In a lot of foreign countries, they're not as generous. They have what's called an absolute novelty requirement, which means you need to get your patent application, in this case a provisional patent application, on file before you put your invention in the hands of the public. So assuming one has not put their invention in the hands of the public before that provisional application filing date, within 12 months or by January 1 of the following year, they can file one of these PCT international applications. And that's an application. It doesn't become a world patent, but it's an application process that one files off of into individual countries. And the main advantage of that PCT application is that it buys one an extra 18 months to get their patent applications on file in individual countries. And that's a real benefit, because essentially from the provisional application filing date, now you're looking at, it'd be 12 plus 12 plus 6 would be 30 months from your provisional application filing date in which you have to file in your foreign countries. And the foreign country process, depending on the country, can be expensive. A country like US, or English-speaking countries like Canada, Australia, might be $2,500, $3,000 to file. But if you're looking at filing in Europe or Japan or China, you might be looking at $6,000, $7,000. And so being able to wait 30 months to make those expensive decisions is very beneficial, because hopefully by that time you have a better feel for the marketability of your product, and you have a better feel for whether it makes sense to make that kind of investment.
Yeah, you brought up some great points there. I was taking some notes myself, so hopefully everyone out there is as well. Okay, so we filed a provisional patent January 1, and we're starting to approach that 1 year mark. How early should somebody start the non-provisional paperwork and filing? How long would a normal attorney need to get that paperwork submitted by that 1 year mark exactly?
Yeah, I recommend that you start getting in touch with a patent attorney 3 months before that point. So in this case, that would be by October 1st of the prior year, and really, I mean, the patent attorney wants to be started on this, getting started on this by 2 months before the deadline, which would be November 1st. And most patent attorneys, they want to have the ability to have 2 months to get their non-provisional patent application prepared. In some cases, that they don't have that luxury, and so they have to prepare it sooner. But the more time you give your patent attorney, the better product you're probably going to have in the end. So that's what I recommend.
I agree. You got to remember, as you are contacting these patent attorneys, of course, you want to get a few quotes, make sure your pricing is fair, and then secondly, keep in mind that these patent attorneys aren't just sitting around twiddling their thumbs waiting for you to call. You've got to think ahead. Remember, they've got a busy schedule. They've got to be able to make sure they can allot enough time for your patent application to be filed, and that way you're not missing any deadlines and losing out on your idea and protecting it. So Stephen, as we start to wrap up, a few last questions. For a lot of the members of our community, they have a great idea. They want to develop it, get it to a point where they can sell it, but maybe not go full time. I'm going to quit my job and start a business around this one product. So we've talked, and I've shared with them some info on how licensing works. Can you walk us through the process? And a company, say they file their provisional patent January 1. Throughout the next 6 months, they're trying to license their product. And let's say a company says, we really like it, we want to take the next steps. What is important about that provisional patent when you're presenting an idea to a company for licensing, and how does that impact their decision to ultimately license your product?
Yeah, well, the provisional patent application, and if you have the results of a patent novelty search, would definitely be influential with someone who's looking at licensing your technology. The more comprehensive the provisional patent application is, the company will look favorably upon that. If the patent novelty search results appear to be positive with respect to your technology, and you have that, you can show that to them as well, that will certainly be favorable. But you definitely want to have your patent application filed before you get in any discussions with any companies about possible licensing. That once you file your provisional patent application, your patent pending, and you have your place your in line, basically your priority date set with the patent office, and the company can't take your technology and try to file their own provisional patent application or non-provisional patent application. So certainly, yeah, you want to have a comprehensive provisional patent application on file, then hopefully have the results, the positive results from a patent novelty search, and that will help persuade the company in the value of your technology.
Yeah, and a lot of folks are scared that, hey, I've got this great idea. If I show it to anyone, what if they just steal it? And that's where having an NDA and that's where having a provisional patent helps build layers of security. There's no golden ticket that automatically is going to stop that company from trying to rip you off, but you have to remember today's internet age, information and access to it is everywhere. And if a company is really, distrustful, they're going to ultimately be exposed in the marketplace. So what I've been told, and Stephen, you can comment on this, that a lot of companies are getting better about not ripping off, say, people who want to license them ideas because of just the clarity and transparency that's established itself in the marketplace. Do you typically find, or have you heard some stories of individuals without protecting themselves that have shown it to a company that did indeed rip them off?
I can't think any off the top of my head where somebody, where it was clear that a company ripped off an individual. I mean, certainly I've, over the last 20 years, I've heard of situations where people felt like maybe a company ripped them off, but usually what happens is the company develops something that might be similar, but it's definitely different. And so then the question is, well, did they really rip them off or not? The other thing to keep in mind is that a lot of these companies, some of them have very big research and development departments, and they might be already working on something in a similar field or a similar product before you disclose your invention to them. So that is often the case. I mean, if one was able to realize the need for a solution to a particular problem with respect to a product, there's a decent chance that a research and developer engineer or the like at a company, that's getting paid, and that's their professional job to look for those solutions. They might have worked on something similar in the past, or might be in the process of working on something in the past. And that's why you'll see in these non-disclosure agreements, NDAs, and/or confidentiality agreements, that they're at least in the state of California, there's certain things that that are not part of a confidentiality agreement that they'll list out. For example, if the company has already worked on something similar, they can't be just by disclosing something that they've already been working on to them, you can't hold them on, you can't restrain them on that. And that's just common sense.
Yeah. And that's one of the things when you look to apply online to especially large companies. These are the ones that are going to have that budget set aside to, put maybe even tens of millions of dollars into research and development. And as you grow and you want to remain at the, top of the marketplace, you need to keep evolving and innovating. So when you'll go to larger companies to try and pitch them your idea, most often they'll have an online product or idea submission place. And if you go through and start to read the fine print, you'll see very clearly what Stephen mentioned is it says point blank, if we already have an idea or we may already be working on something like yours, then tough. We beat you to it. Thanks for your idea, but one, we're not going to license it because we've already got something better. But I was always scared, well, maybe they just say, oh, we're working on it, when maybe they weren't, and they see my idea and think, wow, that's good, let's develop it quicker, because clearly with their resources, they're going to be able to get it out way quicker into the marketplace than any one person. But I know that was a fear of mine in the past. So with that, Stephen, I didn't have any other questions that I wanted to go through with you now. I think you gave us a lot of great content for our group, and I think that you've taught me more and more every time I sit down with you. I feel like I take away some nuggets. So thanks for your time today.
Yeah, it's been a pleasure. Thanks, Vince.
Great. And you guys can of course get in touch with Stephen at the information listed on the screen. He's always available for consultation, and whether or not your product or idea is the right fit for him and his team, he I'm sure will be more than happy to direct you as best as they can. With that said, always a pleasure to talk with the community here with the $1 Million Product team, and glad we're getting a chance to learn from another professional today. Thanks for tuning in for the content, and can't wait to keep helping you develop the product of your dreams and send you on your way to making it happen.